So, why don't we get started here? So welcome everyone to the Northeast Regional Virtual Conference for the Social Studies, or as we call it, Virtual 2020. Today is our day one of this conference that will last throughout the month of October and into November. And today and tomorrow, we are offering a number of keynote sessions, some really great keynote sessions. We have David Hudson, who is with us today. And then later this afternoon, we have Dan Osborne from Primary Source, and based out of Watertown. And then tomorrow, we have a couple of other speakers, Monday afternoon between 3 and 6. So welcome. And what are you going to talk about today?
I'm going to talk about unsettled issues in student speech law, and also a burning First Amendment issue regarding public school teachers that I think are issues that continue to percolate and that have not been settled. So is it good to?
Yep. Let's move on. Yeah.
Okay, so thanks so much for listening to me. I love talking about student speech law, as Gorman knows, and I appreciate the invitation from him. There are, in my mind, three really pressing issues and unsettled questions of student law regarding student speech law and the seminal student speech case, Tinker versus Des Moines Independent Community School District from 1969. And just as a matter of review, the Tinker case is oftentimes referred to as the black armband case. It was decided on February 24th, 1969 by a 7-2 vote. And the court essentially held that Iowa public school officials violated the First Amendment rights of Mary Beth Tinker, her brother John Tinker, and the late Christopher Eckhart when they suspended them and a few other students for wearing black peace armbands to protest the Vietnam War, to mourn those who had died, and to support Robert Kennedy's Christmas truce. And one of the reasons why the Supreme Court ruled in favor of those students was that the court held that the wearing of the black peace armbands was a form of peaceful political speech that did not cause a substantial disruption of school activities or invade the rights of other individuals in the school environment. The court went on to hold, Justice Abe Fortas writing, that undifferentiated fear, apprehension of disturbance is not enough to overcome the right to freedom of expression, that schools are not enclaves of totalitarianism, and that students are not simply closed circuit recipients for only that information that the school wishes to impart. So Tinker is sort of considered the paean of, and the pinnacle, if you will, of student rights. And subsequently know that the Supreme Court in subsequent decades started chipping away at the Tinker opinion, and there have been three major carve-outs. The first one was in 1986 in Bethel School District versus Frazier, where the Supreme Court held that public school officials could prohibit vulgar and lewd speech in the form of a student who delivered a speech before the 600-member student assembly that contained sort of sexual innuendo type language. 2 years later, in Hazelwood School District versus Kohlmeyer, the United States Supreme Court ruled that a public school principal did not violate the First Amendment by ordering the censorship of two articles, one which dealt with the impact of divorce upon teens and one which dealt with teen pregnancy. And the court essentially created a new standard for school-sponsored student speech, writing that educators do not offend the First Amendment by exercising editorial control of the style and content of school-sponsored expressive activities, so long as their reasons for doing so are reasonably related to a legitimate pedagogical or educational purpose. And then about 20 years later, in Morse versus Frederick, aka Bong Hits for Jesus, the United States Supreme Court held that public school officials could prohibit student speech that they reasonably believe advocated the illegal use of drugs. So we've got the Tinker case and the three carve-outs, but there's still some unanswered questions that are out there in this universe. And the first one I'd like to talk about relates directly to the Tinker Standard. And when we think of the Tinker Standard or the test, most of us think of substantial disruption. And in the decades since Tinker, that is still the dominant mode of analysis when we apply the Tinker test. Did school officials reasonably forecast that the student's speech will cause a substantial disruption or material interference with school activities? But there's another part of the Tinker test that the United States Supreme Court has never explicated, and that's what's referred to as the invasion of the rights of others. In other words, when does student speech invade the rights of other students? The United States Supreme Court has never addressed that. It mentions it in dicta in the Tinker decision and goes on to say that Mary Beth and John Tinker and Christopher Eckhart did not intrude upon the rights of other students. But when we live in an era of social media, when we live in an era of so-called cyberbullying, there's certainly instances in which some students can engage in speech that is arguably quite harmful and harmful and negatively impacts other students. We've gotten a few tea leaves from lower courts. So back in 2005, in a case called Harper versus Poway Unified School District, the Ninth U.S. Circuit Court of Appeals held that a public school student who wore T-shirts with Bible verses from Leviticus with anti-gay and lesbian messages on them invaded the rights of gay and lesbian students, which the Ninth Circuit referred to as a discrete and insular minority. Another federal court ruled that two male students sexually harassing speech toward a female student constituted the invasion of the rights of that student. Unfortunately, we don't have a lot of guidance, though. And the reason why we desperately need some more guidance in this area is primarily because of the expansion of student speech via social media. When does some student speech on social media invade the rights of other students, invade the rights of teachers, invade the rights of principals or assistant principals that they speak quite negatively about? And frankly, it's an unanswered question. Now, some scholars writing about it, and I've sent Gorman a link to an article where I've discussed these issues I'm talking about that I hope you'll get a chance to look at some point. But essentially, a lot of people say, well, it should be speech that would be akin to speech that causes an intentional infliction of emotional distress, which is a concept in tort law that prohibits intentional or reckless conduct that is outrageous and beyond the pale of decent society and causes another severe or serious emotional distress. I think there's got to be some kind of standard because otherwise it could devolve into punishing any student speech that is considered merely offensive. And there's a long line of First Amendment precedent that holds that student speech that is merely offensive, or speech in general that is merely offensive, is protected by the First Amendment. It also runs headlong into another fundamental free speech principle that we have in society that was encapsulated by the Supreme Court's decision in Cohen v. California in 1971, when Justice John Marshall Harlan II famously wrote, quote, "One man's vulgarity is another's lyric." In other words, there's a lot of speech that some may consider offensive, but it's not offensive to other people. So that's the first sort of major unsettled question that we have in the student speech landscape. The second unsettled area concerns what happens when we have a student who utters speech in an entirely peaceful manner, and the only reason there is a resultant disruption is on the part of the listeners or recipients of that speech who essentially want to impose a heckler's veto upon the speaker. That also is a divided question among the lower courts, or I said that rather poorly. It's a question that divides lower courts. So that in the Tinker case itself, the United States Supreme Court reiterated several times in the opinion that Mary Beth Tinker, John Tinker, and Christopher Eckhart were entirely peaceful. They themselves merely wore the black armbands. School officials passed a no armband rule specifically because there were students in that school district who had older siblings who had fought and a few had died in Vietnam. And so school officials feared that that would cause those students to perhaps react quite negatively to that speech. So again, what happens if we have a student, for example, who comes to school with an inflammatory, let's say, political message on his t-shirt, and the student is entirely peaceful? He doesn't antagonize anyone. He doesn't say anything. He just silently comes to school with a picture of, maybe a MAGA shirt or a MAGA hat. There's several MAGA hat lawsuits running around in the federal courts now. Other students then see that message, and they, in an attempt to, in essence, silence that message or counter that message or mute that message, they are the ones who act in a very disruptive manner. Does that matter when we analyze the First Amendment rights of the speaker? Let me give you a case that in the First Amendment community that caused a lot of controversy that's written about in the article that I sent to Gorman. And that's a case called Dariano versus Morgan Hill Unified School District in California. In this case, you had about 5 Caucasian students who wore t-shirts with pictures of the American flag to Live Oaks High School, and they did so specifically on May 5th, Cinco de Mayo. There was a prior history the year before of a significant amount of tension between Caucasian and Latino students. And so an assistant principal, when he sees these students wearing the pictures with t-shirts of the American flag, then hears from a couple Latino students that say, look, if you don't do something here, there's going to be some trouble. The assistant principal, acting out of abundance of caution, then tells these 5 students that they cannot wear t-shirts with pictures of the American flag. They and their parents do not appreciate this censorship, and so then they file a First Amendment lawsuit. The case goes up to the 9th U.S. Circuit Court of Appeals, and the 9th Circuit, applying Tinker's substantial disruption test, reasons that in light of the totality of the circumstances, which includes the tension between Caucasian and Latino students the year before, it was a reasonable decision by the assistant principal to prohibit students from wearing t-shirts with the American flag. That case there was a cert petition filed to the United States Supreme Court, but the United States Supreme Court declined to review the case. There were many in the student speech community who were concerned about the case and kind of concerned that a student can't wear a t-shirt with a picture of the American flag, notwithstanding the specific context and conflict that had occurred at that specific high school. Judge O'Scanlan wrote a blistering dissent in which he said that essentially the majority of the 9th Circuit had sanctioned abject viewpoint discrimination and punished students who were entirely peaceful based upon the school district's belief that other students would react disruptively or negatively toward their peaceful speech. There's a conflict between that 9th Circuit decision and a decision out of the 7th Circuit that essentially held that it does matter when we consider the substantial disruption calculus of did the speaker act in a non-peaceful manner, or was it the recipients or some recipients of the speech who acted in a non-disruptive manner? Once again, the United States Supreme Court has never directly answered this question, and it's one that we need some guidance on. The third major unanswered area in student speech law is the one that probably gets the most attention, and I would argue is actually the most significant unanswered question that we have in the student speech landscape. And that is essentially, how long does the arm of school authority extend to off-campus online student speech? The first question in these cases is, do the school officials even have jurisdiction at all over purely speech that was created off campus? So let's say that we have some students who create a Snapchat video, and that Snapchat video has some very offensive content. They create it on their own computer, off campus, never intend for it to be distributed at school, but somehow it's circulated to another student. And then when it's circulated to one student, it suddenly mushrooms and circulates to other students, and then there's some sort of controversy. Do school officials have jurisdiction to even regulate that? There are a pair of off-campus student speech cases that were decided in the 1980s that are fairly instructive, and they were decided in very different ways. And I'll speak about both of them very briefly. One case involved a student in the state of Maine. The case is called Klein versus Smith. Was decided by a federal district court judge in 1986. And it involved a student who did something that was quite disrespectful. He was at a restaurant. This restaurant was located about 3 blocks from campus, but obviously he's not on school grounds. He's not in class. And the student sees a teacher that he does not like. And so he gives the teacher the middle digit salute. In other words, he flips him the bird. The teacher views that obviously as a contemptuous act of disrespect, reports the incident to the school principal, and the student ends up getting suspended for 10 days for disruptive conduct. The case goes before the federal district court judge, who actually begins his opinion by some poem from Samuel Johnson, but ultimately concludes that the digital posturing of this splenetic, ill-mannered little boy is far too attenuated from school activities to give school officials actual jurisdiction or power over it. In other words, it's really a matter for parental discipline, not school discipline, because it didn't take place at school. That's one approach. That's one approach that some student speech advocates take. Now let's contrast that with another federal district court case, this one not from Maine, this one from Pennsylvania, the Fenton case, involving a student who is at a school, is at a mall, is actually at a shopping mall, relatively near school grounds, but once again, it's not during school session. And it was either in the mall or in the car in the mall parking lot. I can't actually remember the exact facts, but pardon my language, but he calls the teacher a quote prick. The teacher then reports that to the school principal. The school principal imposes a suspension on the student. And the federal district court in Pennsylvania rules that this student has no First Amendment right to engage in such speech, because that student's disruptive act is going to cause other students to engage in other types of offensive disruptive acts. And there is some type of connection between this off-campus student conduct and something that actually takes place at school. So what we see from these two cases is very divergent approaches that the courts have taken to off-campus speech in general. So what are the courts doing right now with regard to social media speech. Most courts are applying the Tinker case. In other words, can school officials reasonably forecast that a student's off-campus social media expression will have a disruptive impact on school activities? But it's important to realize that before a court can find that school officials have jurisdiction, they have to establish a clear nexus or connection between the off-campus student speech and something that takes place on campus. It's what's referred to as the nexus inquiry or the nexus test. So what these courts do is they first say, okay, is there a nexus or connection, or is it purely off campus? If it's purely off campus, then the student speech precedents don't apply, and the student is entitled to the full panoply of First Amendment protections that adults do, frankly, when they're out in free society. If, however, the school rules that there is enough of a nexus or connection, then the court applies the reasonable forecast of substantial disruption calculus, and will hold, well, did the student, for example, intend that members of the school community access this information at school? In other words, what's referred to as the intended audience rationale. Furthermore, did the students talk about their speech at school? Did they do anything to actively promote other people talking about it or writing about it? Other courts don't use the nexus test. They use what's called the reasonable foreseeability test. And under the reasonable foreseeability test, it's very close to the nexus test, but essentially under that approach, the question is asked, was it reasonably foreseeable on the part of the students that their off-campus speech would be broadly accessed in the school community and would have detrimental, tangible impacts at school? And we can all recognize the fact that some off-campus online student speech is going to have some tangible impact on schools. However, the Third U.S. Circuit Court of Appeals just issued a ruling a couple months ago in which they said that Tinker has no place for purely off-campus online student speech, that it's not a school speech case, and that it's a dangerous precedent to allow school officials to reach into the confines of the home and assume the role of the parent and punish the student for something that did not take place at school. So we have, once again, another circuit split. I would argue that it's the most pressing question that we need some more guidance on. And it's fairly clear to me that there's some instances where school officials are over-exercising their jurisdictional authority and punishing students for stuff that, frankly, is purely a matter of parental discipline or law enforcement if it involves a true threat. But there's a difference between parental authority and law enforcement authority and school officials. And I do think we as a society have to be careful in allowing school officials to reach into the home and punish kids when they're doing stuff that's entirely on their own time. It's just not a matter of school authority. Now, another reason why this is so important, I think, particularly from the perspective of teachers and other school officials, is sometimes students will get on social media and they will say some very nasty things about teachers and school officials. And so then the school official goes to the powers that be and says, look, I need some relief here. I'm being subject to a campaign of vilification online, and it's impacting my emotional health. It's impacting my teaching. It's just a bad thing. We actually have a phenomenon of some public school teachers and principals and assistant principals actually filing defamation lawsuits against students for false and defamatory information conveyed on social media about them. And that is a lesson, I think, for young people, is that with rights come responsibilities. And when you post something on social media, that's not a legal free zone. Now, the school may not have jurisdiction to punish you for it, but even if the school doesn't have jurisdiction, the courts have jurisdiction if somebody files a defamation lawsuit, right? And defamation involves a false statement of fact that harms another's reputation. If somebody gets online and says David Hudson is a lousy teacher, I don't think that's true, but that's their opinion, right? Oftentimes opinion is protected. It's certainly not something I'm not going to sue over, right? But if somebody gets online and posts that David Hudson is a convicted sex offender, I would seriously consider filing a lawsuit. That is flagrantly false information. And if that was disseminated widely, that false information is obviously defamatory. And if certainly if people believed it, which they shouldn't obviously, but if they believe that, right, that would harm my reputation. And so I think another reason why this is an area that I think deserves a bit more explication eventually from the United States Supreme Court is that students deserve an answer, parents deserve an answer, school officials deserve an answer, and certainly administrators deserve an answer as to exactly how far the arm of school authority extends. It's my belief that some school administrators are flagrantly and egregiously overextending their disciplinary reach and punishing students for stuff that's purely off campus. Now I want to shift gears slightly and talk about another issue in school law that I think is arguably as important as all of the previous three questions that I mentioned. And if we go back to Tinker, what did Justice Fortas say? He wrote something to the effect, and I may miss some language here, but this is pretty close. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. In other words, the Tinker case itself holds that it's not just public school students who have First Amendment rights, it's also public school teachers. In a year before the Tinker case, the United States Supreme Court decided a case called Pickering versus Board of Education 1968, which is really the Tinker case for public school teachers. Marvin Pickering was a high school science teacher from East Lockport High in Illinois. And Marvin Pickering sincerely believed that his school district or his school board was allocating way too much money for athletics, particularly the building of a new football field, and essentially shortchanging what it ought to be doing for academic improvements. In other words, the school's paying way too much on athletics vis-a-vis academics. So Marvin Pickering writes a letter to the editor to the Lockport East Herald, which is the local newspaper where he lived in his community. Interesting, he showed the letter to his wife. When I lecture about this case, I often refer to it as the listen to your spouse case, because his wife said, well, look, I agree with you and I respect the fact that you're saying this, but if you send this letter, you're going to get fired. And he's like, well, I don't think so. He sends the letter in, it ticks off the school board mightily. He ends up getting fired. While his case progresses through the Illinois state court system, eventually up to the United States Supreme Court, he's blacklisted. He can't get a teaching job in the state of Illinois. He has to go work at a Campbell soup factory in Chicago for 2.5 years to support his family. Ultimately, the case goes up to the United States Supreme Court, and in an 8-1 decision, in a great opinion written by Justice Thurgood Marshall, the United States Supreme Court said in these cases, we have to balance the interest of the public employee as commenting as a citizen on matters of public concern against the interest of the employers interest in a disruptive free workplace and an efficient workplace. So the first inquiry in these type cases is, did the public employee speak on a matter of public concern, or is it merely more akin to a private grievance? And the United States Supreme Court found that Marvin Pickering's speech about how the school board allocated its money was a matter of public concern. It was a matter of significant public interest in that community. Because it was considered to be a speech on a matter of public concern, it then had to be balanced against the school district's interest in an efficient, disruptive free workplace. And the key tipping point in Marvin Pickering's case is Justice Marshall emphasized that Marvin Pickering did not speak negatively about other teachers, his principal, or his students. In other words, he did not speak negatively about anyone with whom he had close working relationships with, and therefore they cut the balance in favor of Marvin Pickering. As this case law developed in 1983, the court decided another case called Connick versus Myers. That case did not involve a public school teacher. It involved an assistant district attorney who was upset that she got transferred to another office location. She was very upset about it, and so she circulated a questionnaire in the workplace that asked things like, do you feel pressured to support political candidates that the district attorney supports? The district attorney happened to be Harry Connick Sr., the father of the famous musician, and somebody who ruled the office in a fairly authoritarian fashion. He called her in the office and said, did you distribute this questionnaire? She said, yes. He fired her. The court applies this Pickering analysis. It said, first, did anything in this questionnaire constitute speech on a matter of public concern, or was it merely a private grievance? The court held that the bulk of her questionnaire was more akin to a private grievance, but that one question about whether employees felt pressure to work on political campaigns, that did touch on a matter of public concern, so they balanced. But unlike Marvin Pickering's speech, this time the court, by a single vote, 5-4, ruled that the employer had a strong interest, the district attorney's office had a strong interest in avoiding speech that would cause a disruption of the workplace, and therefore they ruled against Sheila Myers. That's the standard we had for decades, this so-called Pickering-Connick analysis. That changed fundamentally in 2006 when the United States Supreme Court decided a case called Garcetti versus Ceballos, a case that's had a terribly damaging impact on public school teachers' First Amendment rights. Now, the Garcetti case did not involve a public school teacher. It involved another assistant district attorney. But this district attorney, Richard Ceballos, receives a phone call from a criminal defense attorney telling him that there's a case that you have in your office in which there's perjured law enforcement testimony on a search warrant affidavit. It just so happens that Ceballos had handled a case with his defense attorney and they had a high degree of respect. So Ceballos does some investigation, and lo and behold, he comes to believe, wow, this defense attorney's not lying. This sheriff's deputy lied on this search warrant affidavit. So Ceballos writes a memo advocating that the criminal charges be dismissed because there's perjured law enforcement testimony. His superiors don't like that, and ultimately the charges aren't dismissed, and Ceballos is not fired, but he's stripped of his supervisory role and he's transferred to another office where he had a much longer commute. So he argued he was retaliated against. Under the traditional Pickering-Connick test, Richard Ceballos would have prevailed. Why? Because speech alleging that there's perjured law enforcement testimony is a matter of imminent public concern, and there was no real showing that the speech disrupted the office. But guess what the United States Supreme Court did by a single vote, 5-4? They created a new rule. When public employees make statements pursuant to their official job duties, they have zero First Amendment protection. Doesn't matter if they're a whistleblower, doesn't matter how important the speech is. If it's official job duty speech, no First Amendment protection. Now we can see the Garcetti rule having a very negative impact on public school teachers' First Amendment rights, because arguably much in-class teacher speech is considered official job duty speech, and therefore under Garcetti, it has no First Amendment protection at all. The Lincoln Brown case is instructive out of the city of Chicago. Lincoln Brown was a public school teacher who got a note, caught two of his students passing notes. The note had the N-word on it. So Lincoln Brown said, okay, I'm going to make this a teaching moment. And he talks about the N-word and other racial slurs and ends up talking about how negative and damaging they are. Unfortunately, a school official happened to be walking down the hallway and heard Lincoln Brown utter the word and didn't really appreciate the context in which Lincoln Brown was saying this. He ends up getting a suspension. He files a First Amendment lawsuit, and the 7th U.S. Circuit Court of Appeals rules against him. Why? Because of Garcetti. They say that his in-class lecture about this was official job duty speech, and he has no First Amendment protection at all. Now, Garcetti does not apply to the main issue that I wanted to talk about with regard to teachers. The main issue I want to talk about with teachers is when teachers get on social media and they make, let's say, controversial posts. And then somebody in the community then circulates this controversial post and it causes a firestorm or a maelstrom in the community, and then the teacher gets disciplined. I can't even tell you how many of these incidents are happening. I just know it's happening everywhere. I wrote an article in June that I'll send to Gorman that he can circulate to you, in which in 1 month I found 5 of the incidents that were reported in various media outlets. The problem for the public school teacher is if you make a post on social media that impugns other teachers, that impugns students, or impugns anyone with whom you work with on a day-to-day basis, it's not going to be a Garcetti problem, but you're going to lose probably under the Pickering balancing inquiry, because the court is going to say, well, that has a really disruptive impact because unlike Marvin Pickering, your controversial social media post is going to have tangibly negative impacts on other people that you were speaking negatively about. A closer question to me is, let's say that a public school teacher gets online and just advocates their sincere political beliefs. Let's say it's speech that's either very very laudatory or very negative toward BLM. And then somebody in the community considers this post to be, let's say it's, there's several cases out there where public school teachers have said stuff that's quite negative of BLM, and then they're accused of making racist speech. It causes an uproar at the school, and they suffer some sort of adverse employment action or get some sort of discipline. Some courts may well view that type speech as not protected under this context, which is interesting because you are supposed to retain the right as a citizen, right? You don't always have your employee hat on, right? You often have your citizen hat on. And should your rights to political speech be muted or punished simply because you hold political views that may be different from whatever political views are being advocated by your school system or whatnot? You know, I lecture quite a bit to groups of public employees about these social media cases, and I have to be honest. I say, I think that you have to be very careful what you post on social media. Why? Because even if you have it on private settings, it somehow gets out, and then there's an overreaction, and then, you know, you're in the midst of a free speech controversy. So let me try to wrap up, and then I'll open it up for questions if there are any. To me, there are really 4 key questions that we really need a bit more guidance on. The first one is, what exactly is invasion of the rights of others? When does student speech invade the rights of other students? question desperately needs answers, particularly as schools have all these sort of anti-cyberbullying policies and anti-bullying policies. Second major question, when we're evaluating a student speech question or a student speech controversy, does it matter? Does it cut in favor of the student that that student himself or herself was quite peaceful and the disruption was caused by those who simply want to create a disturbance and sort of shout down the speaker? In other words, does it matter for purposes of substantial disruption who causes the disruption? The third major question is, how far does the arm of school authority extend to off-campus social media student speech? And then the fourth question is, are public school teachers' free speech rights in terrible peril, one, as a result of Garcetti, and two, as a result of this obsession about what they say on social media? So that is my overview of the what I call pressing questions in school law and the First Amendment. I don't know if
Right.
I might be able to answer any.
Yeah. So I had thought some questions, and you kind of alluded to that in the 4 questions that you presented, but first thinking in terms of, I think it was only about a week ago, there was a 9-year-old boy in Louisiana. I'm not sure if you are familiar with this story. It was a remote learning class. So the student was at home, but they were on, I forget if it was a Zoom or a Google Meet, or it was basically, you know, a remote learning class. The 9-year-old boy just happened to have a BB gun that was shown on his desk, or maybe it was in the background or something. Teacher caught that. The boy was suspended because of showing the BB gun. Now, I don't know the full context. You know, did the boy just showed it on camera, or it just happened to be visible in the camera? So the question I was thinking, you know, of asking you is like, what do you say about that particular case? What do you feel like the schools could have done, what they should not have done?
I think that's an overreaction myself, unless he pointed the gun at somebody or threatened to shoot another student or said he was going to bring it to school and shoot somebody. I think that's a gross overreaction. I mean, what do you have to do? Go through and put students in 4 white walls with nothing on the walls and like they can't say anything? You know, I mean, I just find that to be zero tolerance, run amok.
Right.
That's my opinion.
So in kind of like dovetailing to that, what would be, I mean, and this is maybe, you know, part of the 4 questions that you presented, but the set of, like, what would you say as a recommended set of questions or conditions that school officials must consider in responding to a complaint by, let's say, fellow students or by a parent who, you know, if a parent complained to the principal or the teacher, it's like, hey, look, you know, I just happened to notice while my son or daughter was in a remote class and another student showed a Black Lives Matter poster in the background, or a swastika, or a pride flag, and this parent is making a formal complaint. How do school officials wrestle with
that's tough.
whose rights are more, you know?
I of course, you know, I may, in full disclosure, I do represent a couple students now in a social media case that I think is an act of egregious censorship on the part of school officials. So I may not be the most unbiased. And the question's a great one that I'm not sure I have an answer to, because I don't know if we've ever had these remote type classes before in this context. But to me, it would have to rise to the level of something that was so distracting that it disrupted other students' ability to learn. So I guess we could possibly conceive of something that was so disruptive to the learning process that perhaps it needed to be moved. But a lot of this stuff, I think, really, it's unfortunate that people can't have political opinions, and somebody ought to be able to have their Trump sign, somebody ought to be able to have their Biden sign, somebody ought to be able to have their third party political candidate sign. You know, I just think it's, you don't have a right not to be offended in a free society. And, you know, but I can see that there may be something that if it severely distracts other people from learning, that would be what I would be concerned about.
Yeah. So the question would be, as a school official, how would you respond to the parent complaint? Because they might push, like, saying,
Well, I would tell them, you know, look, it's a free society, you know, people have the right to different opinions and
yeah,
political beliefs, and we don't have a state mandated orthodoxy on what people can believe in a free society. So that kid may have parents who have strong political beliefs that are different from yours.
right,
Tough.
right.
Probably why I'm not an administrator, but
All right. I think Tom has a question, so I'm going to unmute him.
Can you hear me now?
Hi, Tom. Yes, we can
Hey,
hear you.
good afternoon. Great presentation, David. Just
thank you.
fabulous.
Thank you for being one of the two people that came.
Yeah, well, man, I think I heard you about 3 or 4 years ago up in New Hampshire at a
Oh,
conference where the Tinkers came.
I was thanking Gorman for that, and Dave Alcott. That was really great. That was so fun.
Yeah. So my question is, the Tinker case was decided by a very liberal Supreme Court.
It was.
And what we've seen and your delineation of cases since then have progressed negatively towards free speech as the court has become more conservative.
Yes.
So that's sort of
Yeah. A couple
that's
points
my
on
question. What that
Yeah.
free speech is going to disappear because of political correctness and the ability of conservatives to not really be what are the Federalists, strict constructionists, you know? They're going to figure out something else. So you can't, I knew from my schooling that you couldn't yell fire in a theater.
that. Right. Can't
That was
fault
about
you.
it. After that,
Yeah.
and if you look at free, what political campaigns were like in the 1800s, man, they were really vicious.
Right.
And we don't see anything like that. But I'm just, with the Supreme Court really approaching a 6-3 margin.
Yeah. Tom, I
your
will say this though. In Morse v. Frederick in 2007, 8 of the 9 justices did reaffirm Tinker. It was only Justice Clarence Thomas who would have overruled it. And there was an argument made in that case. I do think this is significant. There was an argument made in the case by Ken Starr, actually, of all people, who represented the school pro bono. And his argument was the Bong Hits for Jesus banner can be prohibited because it's offensive. And there were a lot of conservative religious groups actually filed amicus briefs, believe it or not, in support of Joseph Frederick, not because they supported Bong Hits for Jesus, but because they said we can't empower school officials to regulate any student speech that they perceive as offensive. After all, much political and religious speech could be offensive to some. And Chief Justice Roberts, in his majority opinion, actually accepted that rationale. He said that stretches Frazier too far, so that the Frazier opinion only prohibits vulgar and lewd speech, not plainly offensive speech. So it was an example of a conservative jurist protecting free speech. Now, he did ultimately rule against Joseph Frederick, but it's hard to argue with your main point that certainly the court since Tinker has been more conservative and there's been a lessening of student speech rights. So I totally agree with you but I do think that was one good point that Roberts made in his majority opinion. And I'm glad that only Justice Thomas is the only justice that would overrule Tinker.
All right, thank you. But
Absolutely.
it's,
Thank
you know,
you.
it's like little pecks being taken away at Tinker, slowly but
Yes,
surely.
absolutely. I think you're right. I think
And
you're
pretty
right.
soon you don't realize it's gone.
Yeah, that's why we all have to be vigilant about free speech. And
Yeah.
you know, thank you for the work you do.
Well, listen, keep up the great work, David.
Thank you,
Appreciate it.
sir.
Thank you.
Tom. Stay in touch. Gorman has my email. Feel free to reach out anytime.
All right.
Yeah, just thinking about like what you just said, like, are there other legal moves to preserve, to secure, for lack of a better word, the Tinker case? You know.
Yeah, I mean, I do think that the so-called it's had different names through the years, but student journalists have been pretty active in trying to sort of combat the Hazelwood case specifically and grant greater free speech rights to student journalists. And I think we have now, is it 9 states? I can't remember the exact number, but there's a number of states that now have these so-called anti-Hazelwood type laws that provide greater statutory protection for students than constitutional protection. And so you remember, if the Constitution can't save us, maybe we can have statutory protection. And so I think it's important for student speech advocates to petition legislators and advocate on behalf of laws. I think Kathy Kuhlmeyer, Kathy Fry,
Right.
been very active, and Mary Beth Tinker both been very active on fighting for these different state laws, or been at least quite supportive of them.
Yeah, and you know, I was just saying earlier, like in previous sessions that we had this morning, you know, talking about, you know, here in Massachusetts, you know, the eighth grade social history and social science curriculum now is supporting a law here in Massachusetts on civics engagement in 8th grade. So basically there's a law in Massachusetts that says that every 8th grade student, and also in high school, need to construct or build a student-led, nonpartisan civics engagement project. You know, so it's really focusing on project-based learning. And I'm thinking that this could be, you know, a potential topic for students if they're thinking about, because, you know, I mean, one of the challenges for teachers with in regards to the civics engagement project is, what kind of projects can students think of, you know, and continue year after year after year. And I'm thinking, you know, maybe student speech being a very potential project topic for students across the Commonwealth to consider, and maybe kind of doing some type of project where they're monitoring or following cases, anti-Hazelwood cases, you know.
Yeah, of course, you have a pretty good state law, right? It's fairly protective. I think it's one of the broadest. So, you know, students in your state have more protection, frankly, than students in my state.
Yeah.
That's good.
Well, thank you very much for your time.
Thank you. It's always a pleasure, Gorman. Gorman's one of my people I hold near and dear. I think he's a fabulous human being.
Thanks.
So thank you to the people that came, and hopefully maybe some other people can watch it somehow if it's recorded.
Yeah, this was on Facebook Live, so I know a few people had come see it. But yeah, in the on our website, when you go to the NERC virtual program, you can go to David's page that kind of describes the session. I believe his email is there too, so you can always ask a question. Just click on the link and you can ask him the question. I did put on the link in the chat feature, the link to Unsettled Questions in Student Speech Law. And then I'll also add that to the Facebook page on the comment section, and then also on the page on our NERC virtual. So there's there's plenty of ways to be able to reach out to David. And I know David was more than willing and happy to speak to your staff or to even to your students regarding about speech in schools and classrooms. This was really, really good. I'm really glad that you could come here and talk to us about.
Maybe next year I can come see you, Gorman.
Yeah, absolutely. And maybe
Nice.
we can get a street performer to jump over me next time. So I'm just putting here on the link in the chat a link to the Keynote session feedback form. So please feel free to fill that out after this session, or if you're planning to see other sessions, you can wait to the very end and then you can fill out, but the link is right there. Again, thank you very much, David, for your time.
Thank you. I appreciate it. Thanks to Elizabeth and Tom. I appreciate
it. Yeah, and all right. Well, that's it. Thank you very much.
Thank you, Gorman. Bye-bye.
David. All right. Bye-bye.